closures real quickly, on if you have clients that have properties that are, if they're buying foreclosed properties as opposed to properties are getting foreclosed, which I understand could be an issue. The notice to vacate to parties under a written lease contract is 90 days. It's not a 3-day notice to vacate. So be aware of that under federal law, and I think a lot of the judges are aware of that. I interrupted you. You were going to ask.
No, I was just going to say we're getting close to the end, so yeah, whatever final thoughts you have with foreclosures and those types of things.
That's all I've got. I'll just open it up to any final questions.
No, I'm sure we could take all day with, and this has been very helpful. Maybe one final question. We get a lot of tenant disputes, maybe from neighbors and those types of things. Of hey, this person's parking, in my driveway, or making loud noise, or dog keeps me up at night. You need to take action. And this is potentially between neighbors. And let's say there's something in the lease that says, yeah, tenant's responsible to not,
comply to the HOA rules.
Yeah, and those types of things.
Private enjoyment and so on.
In any of those cases, what's the best advice that, our position, because we're not lawyers, we can't represent those types of things. Or if an owner says, hey, this person is violating this HOA, I want you to kick them out. We, like you said before, we can't evict for anything other than rent. What's a good, something that we can tell either a tenant, owner, or neighbor in those types of disputes?
Well, I think your lease provides for abiding by certain rules and probably HOA requirements as well, does it not?
Yes, it has those. So they're in violation of their lease.
Right, it'd be a violation of the lease. What you should do, the best way to handle that is to give them a warning, and maybe 3 warnings. 3 strikes, you're out. This is a warning. We've received a complaint from the neighbors, and this is a violation of your lease. And then it happens the second time, say we've received another complaint, this is your final,
Before what? What action?
You can do a third one if you want and say, look, this is your final warning, the next time we will proceed to terminate your occupancy. Or you can do it 2, you could just warn them, but I would simply do a warning. It depends on how egregious it is.
So if an owner, sometimes if an owner says, hey, I want you to get them out. Well, we can't take any action right in removing the tenant other than non-payment of rent by way of eviction. Just because they're in default for something other than rent, what action can we take?
You can evict somebody for any violation of the lease, which includes but is not limited to failing to pay rent, failing to timely pay rent, failing to pay utilities, failing to make proper repairs, failing to allow you in.
But those would all require
disturbing
a lawyer.
The peace, any of that stuff.
But they would require a lawyer, right?
Yes,
yeah.
yes, but you can't evict them.
Yeah, yes.
So if the...
sorry, when I meant us non-lawyers. But any violation of the lease, we can evict them, but it would have to be through a lawyer, and we'd still have to give, you said, a notice or something like that.
Notice to vacate.
Opportunity to cure.
I don't know if there's an opportunity to cure on something like that, on violations, and generally not. There's not an opportunity to cure rent ordinarily. You can, if they're late. Right. As long as you don't have a pattern of accepting late rents, you can kick somebody out for that. But you don't want to have a pattern, or you've got a waiver issue. And if you're going to do it, then you probably need a lawyer to pursue it, because it's going to be a little bit, if you end up with a lawyer on the other side, you might not win, and you might have to pay attorney's fees.
Yeah, I was dealing with a situation like that. I think it was one of your tenants, his neighbor called me and I was telling you about that.
Right.
What is because I told her that she probably should call the police and have them file a complaint, and then also talk to the HOA, because some of them have rules about that. What is the burden of proof for us? Because I know that we have to, when you go to court saying, well, they're in violation, I said, well, show it to me.
Well, that's why you're hiring a lawyer and required to have a lawyer, because we're typically serving subpoenas on parties, and you don't have to prove up the criminal violation, and we often have to explain it to the judges. I don't have to, I'm not prosecuting the case, I don't have to win that, but I have to show that it's otherwise a violation of the lease, whatever provisions are. Okay. It's certainly helpful to have warnings, and so it depends on how egregious it is. Loud noise, having a party one day, may not be a big deal, but having repeated parties, neighbors are complaining, and then they're maybe complaining to the HOA, or they're upset with the owner where it's a nuisance and gonna get the owner in trouble, then you probably have to take some kind of action. And at that point is when you're wanting to contact our office and get the advice on how to handle it.
Yeah, I guess maybe a final question. We had 3 or 4 situations this year where on a security deposit, we charge for illegal pets. And we charge, the lease says like $30-something per day per illegal pet, and we just charge up as much as we could. Are we making ourselves vulnerable for
Do you, having an illegal pet is constitutes a violation for which you can evict, and you should be asking them to sign a pet addendum.
This is after the fact.
No, I understand that. After the fact, you find out someone has a dog illegally in there, you need to contact them, say, hey, you cannot remain in the property without signing the pet addendum and paying a,
No, this is after they moved out. We're
Oh,
doing
it's
this.
after
security
they-
deposit.
We're doing the security deposit. We go in, we find, hey, they had a pet. It was not on the lease. We're seeing urine stains, whatever.
How do we establish a start date though for violation?
Well, that's what he's
I
asking.
think
We've
it's every
basically
30
gone
days.
through and
Because at that
said,
point, we're questioning whether we charge for carpet repair based on, the prorated amount of carpet, or hey, we might be able to get more out of them for this owner. if we
because
charge
there's
for
obvious
pet
pet
deposit, which is-
stains. They've lived there 2 years. 30 days for 2 years is
I feel
extensive.
comfortable if you inspected the carpet before then and it was in new condition.
Yeah, before they moved in.
And the pet, even if they have a pet, even if they lawfully have a pet under your lease agreement or otherwise, I don't think it changes. You still have to, whatever deposits you have, you can whatever damages exist, you can offset with any deposits that you have. And of course,
Yeah.
because normally with pet urine, you have to change the entire carpet and the carpet pad as well. It's very difficult, I'm sure you know, to match carpet anyhow, but just because the smell
Oh, yeah.
and things and with the concrete and all of that.
But we've done a practice that we've done is not only the damage, we've gone back and perhaps charged him 1 month of an illegal pet, $30 per day, after a $60 initial charge, on top of the damage of the carpet.
You can try. It's a little bit more difficult, but obviously, I would probably keep with carpet damage claims, if the pictures really don't come out well, and sometimes with like pet urine stains, they may not,
Yeah.
cut out a square sample that looks bad, put it in a plastic bag, and put it in the file, so that you can pull it out.
Oh,
We
God.
have a lot of them.
Here and
We
there,
need
Judge,
gloves.
take it out.
Or, I mean, if pictures aren't going to do it justice, because it's very difficult trying
Yeah,
a
yeah.
case, and it doesn't look that bad, but it's often true that in person it looks a lot worse, and maybe the resolution of the camera wasn't very good, or it's dark carpeting and it's hard to show the yellowness, maybe the pad will show it, take a picture of
Yeah,
that.
if you strip up the pen.
But
smell is
Smell-o-vision.
subjective. Smell is subjective, and we can't prove that with a picture. So even if a tenant has the carpets pro-clean, there might not be evidence, topical, visible evidence of it, but you walk in the house, it smells like urine. That's
Get another witness there as well.
we've got the carpet guys, we got the marketing
Okay.
agent, we've
Right.
got whoever heck was in there to clean the rest of the house. So
Yeah, the more documentation in the file, the better for me if I'm having to defend a lawsuit. Simple as that.
fair enough.
Any final questions, guys? We'll let Israel head out. All right, Israel. We really appreciate you coming. I'm sure we'll continue to use your